Hello and welcome to ACCA CBL Corporate Business Law. This is chapter number 1, which looks at the English legal system. Now, what we've done with chapter number 1 is we've split it down into 2 separate parts. And the reason we've split it down into 2 separate parts is it's quite a big area of the syllabus, but it's a very important area of the syllabus. You will need to have a basic understanding of everything to do with the difference between the criminal legal system and the civil legal system. You also need to understand the court system, and you need to be able to understand which types of courts will deal with what type of action. We'll introduce you to this court system. We'll talk to you about how the civil law system structure and the criminal law system structure is different. And then also we'll have a look at case law within part number 2. Now, within part number 1, looking at the structure of the English legal system, we've got a complete distinction between criminal issues and then civil issues. So we start by looking at the criminal system. So we'll start by looking at the criminal system, and then we'll have a look at the civil system. You should see these two systems as completely different legal systems that work together. They cover different areas. The criminal system, which is the one we'll look at first. In the criminal system, we have action taken by the Crown, which is included within the catch-all net of public law. So action is taken by the Crown. This is where you commit an act, such as killing somebody or stealing something from somebody, which as society we don't like and we don't want you to do. The key objective of the criminal system is to try and punish you and try and regulate your behaviour through that threat of punishment. The civil system is all about private law, and the civil system we have is where one person takes action against another person. So one person takes action against another person, whereas in the criminal system, action is brought by the state. Now what we have is these two different systems sitting side by side, the civil system and the criminal system together. We're going to look at the criminal system first. So we'll take away the civil system to start with. In the criminal system, criminal law is all about trying to regulate your behaviour and regulate your conduct through the threat of punishment. So we're going to regulate society through the threat of punishment. So if you do something that we don't like, we're going to punish you for it. So if you do something we don't like, we will punish you for it. In the criminal system, what actually happens is the state takes action against somebody, and the state will take action against somebody who is known as the defendant or the accused, because they've been accused of a criminal action. If the state can prove their case, then the accused will be found guilty. The burden of proof here is on the state, and the level of proof is really significant. It is beyond reasonable doubt. Now remember, what we're trying to do here is punish somebody. So we want to make sure that we're getting this absolutely right before we try to punish this person. That's why we have this idea of beyond reasonable doubt. If this accused or this defendant person is then found guilty, they will be convicted of an offence. If they are convicted of an offence, then we will sentence them to some sort of punishment. The punishment may potentially be a fine, or it might potentially be imprisonment. So it might be a fine, it could be imprisonment. So there's a couple of different issues here with regard to the criminal system. Punishment, beyond reasonable doubt, the state takes the action against the individual. Within the civil system, what we're looking at is an individual taking action against another individual. The idea here is not to punish somebody. The idea here is to compensate one person. So the idea here is to compensate one person because they've had a loss because of somebody else's actions. So what we will do is we will come up with what we call a legal solution, which is a remedy. So we come up with a legal solution to this situation, which is a remedy. And the remedy here will normally be damages. For damages, read compensation. So the damages, which is compensation, will be my remedy, which is the solution. In this type of situation, it is not the state that's taking action. It's the claimant, the person who wants to make a complaint against somebody else, also known as the plaintiff, because they're making a complaint. They will take legal action against the defendant. They will try to sue that person. So they will try to sue that person. Now, this is not punishment. The objective here is compensation. It's damages. Therefore, we do not need to prove this beyond reasonable doubt. We only need to prove this on the balance of probabilities. So we only need to prove it on the balance of probabilities. That is a key difference. If the court holds in our favour when we're making this type of complaint, the court will potentially order damages to be paid, or it may potentially force somebody not to do something, which is an injunction, or it may force them to do a positive thing, which is specific performance. So we've got two different ways of changing people's attitudes and actions here. Specific performance will force you to do it. An injunction will stop you from doing something. And then you've also got compensation in here as well. Now, the two objectives that we have from these two separate legal systems are completely different. And this is really important to me. The criminal system is trying to regulate society through the threat of punishment. So we're trying to regulate society through the threat of punishment. The civil system is trying to force compensation if we feel that it's the right thing to do. So the civil system has got a much lower burden of proof. The criminal system has got a very high burden of proof. Now, what we have within the criminal system, and you do need to have an understanding of the criminal system, we have got a magistrates court and then a crown court, and this will then fit into the rest of our structure as well. Within the magistrates court, we will have what's known as a JP, a justice of the peace. So you'll have a JP, which is known as a justice of the peace. This JP will be a well-known person who is well respected from the community, potentially from the business community, and they will hear cases in the first instance. So they will hear cases in the first instance. If something comes up and somebody pleads not guilty to an offence, remember these are criminal offences, so if somebody pleads not guilty to an offence, the magistrates court will automatically push it up to the Crown Court. If the offence is so severe that the magistrate can't deal with it, then the magistrate will push that up to the Crown Court. That's when these things become indictable offences. So indictable means we're going to push it up to a higher level court. The higher level court has the power to dispense greater levels of punishment. So the higher level court has got the power to dispense greater levels of punishment, which could be very important to me. Now, within the Crown Court, you've got a judge and a jury. The judge will make decisions on matters of law, so he will decide whether something has happened which is a legal issue. The jury of your peers will decide matters of fact, i.e., did you do something? So the jury decides whether or not you've done it, because they will decide matters of fact, whereas the judge will decide matters of law. Now, staying with this magistrates court. Within the magistrates court, we've got our JP. The JP is not a legal specialist. Therefore, the JP needs specialist legal support. The specialist legal support comes from the clerk of the court. And the clerk of the court will advise the magistrate on how to deal with certain issues. And what will now happen is our magistrate will deal with the vast majority of offences. They will deal with what we call summary offences, where people have pleaded guilty to low-level offences. They will also be the court of first instance for committal proceedings, where we push something up to a higher level court, such as the Crown Court, and other miscellaneous offences, such as debt collection issues for utility companies. Now, if the magistrate is able to deal with it, then they will. If they're not able to deal with it, then they'll push it up to the higher level, a more senior court. This is where the real judges start getting involved. The Crown Court is staffed by High Court judges and circuit judges. These Crown Courts will deal with more serious offences. So they will deal with more serious offences, and they will deal with offences where somebody has said not guilty. So that's the indictment. I've said not guilty to something, not a problem. The magistrate is not going to try and determine whether you've done something wrong or not. The magistrate will just say, not a problem, pass it on to the Crown Court. The Crown Court will now work it all out. If you give out too much of a punishment from the magistrate, then the person is allowed to appeal against that. They appeal to the Crown Court. Remember, the Crown Court has got greater levels of powers. They are more senior than the Magistrates Court, so they could actually impose greater penalties if they wanted to. Now, the way the civil courts work, we've got this wonderful picture of the civil courts. We've got County Court, High Court, Court of Appeal and Supreme Court. Now remember, this is the civil courts now, so this is a different situation. What we've got is the County Court and the High Court will be known as courts of first instance because it's possible for cases to be heard in these two courts first. So it's possible for these cases to be heard in either of these two courts first, depending upon the nature of the case and the severity of it. Remember, this is a civil action, not a criminal action. If you have a situation whereby something's been heard in the County Court or the High Court and the judgment that's been dispensed is not good for one of the two parties and one of the two parties wants to appeal, then they can appeal to the Court of Appeal. So they can appeal to the Court of Appeal. Now, the Court of Appeal will have 3 Lord Justices of Appeal and they will hear appeals from the Crown Court and then also potentially from the High Court. It is possible to then appeal against the Court of Appeal, and that then goes up to the Supreme Court, which is made up of law lords, or the old law lords, so it's Lords of Justice. So the Supreme Court is the highest court in the UK. Now, it is possible to take a case to the High Court, and if that case is so important that the High Court judges that have heard the case decide that we need to make sure that everything is done absolutely perfectly correctly, it's a very important case, they have the ability to leapfrog the Court of Appeal and go straight to the Supreme Court, which means that in cases of national urgency, not emergency, but urgency, we can leapfrog the Court of Appeal. And what this now means is we've got the County Court and the High Court, which is a court of first instance. We have also then got the Supreme Court and the Court of Appeal as appellate courts, which means that appeals are heard there. You could get a multi-choice question on which of these courts is a court of first instance, which is an appellate court. Now, let's go through these courts in a little bit more detail. We've got the County Court to start with. The County Court is staffed by circuit judges and district judges, similarly to the Crown Court. If it's a small, low-level case, then we'll get one district judge to look after it. If it's a slightly harder case, maybe a little bit more difficult, a little bit more tricky, bigger numbers involved, then we'll get a circuit judge involved. Okay, so we'll get a circuit judge involved. If it's multi-track, that makes it a little bit more complex, a little bit higher value again, then we'll push it into definitely being heard by a circuit judge rather than a district judge. So there's a seniority within levels of judges as well. The County Court will look after things such as, remember these are not supposed to be criminal effects, so these are supposed to be civil actions, so they're not criminal in effect. The undefended divorces, bankruptcy, insolvency, contract tort issues, which we'll come to later on within the syllabus, low-level land disputes. Yeah, we're not really too worried about the law of property in this. It's just contract law and a bit of company law that we're interested in. The County Court is a court of first instance. It never hears appeals. And what it does is it uses a track system, specifically a 3-track system. And this 3-track system says that if you've got a smaller claim, which is less than £10,000, we'll just get it sorted out with one district judge. If it's a fast track, which means it's sort of medium value and medium complexity, then we might get a circuit judge in. We might get a district judge in there as well. We may potentially get more than one judge in. If you have multi-track cases, you may have to push that further on up. So multi-track cases, you may now need to push that up. Once this county court has reached this decision, you can potentially appeal. Either party, the person who's making the complaint, the claimant, or the person defending their position, the defendant, can appeal. Now, the appeals from the county court normally go to the Court of Appeal, as you'd normally expect. Some appeals from the county court go to the High Court, which is the HCJ, High Courts of Justice. So the High Court of Justice is a court of first instance and an appellate court in certain instances as well. Now, the High Courts of Justice are staffed by High Court judges, as you would expect. And what happens here is, if you have got a court of first instance issue, you tend to find that only one High Court judge will hear that. They will deal with multi-track claims, more complex, more higher in terms of value. And if you have a situation whereby somebody has appealed against maybe the county court, and we're now acting as a court which is an appeal court, an appellate court, then you may find that we get 3 High Courts judges are hearing this appeal, and then we will determine it based on the majority decision. Now, the High Courts of Justice are split down into 3 different divisions. So my High Courts of Justice are split down into 3 different divisions. And we're going to look at these different divisions in a little bit of detail. So we'll just get straight into it. The Queen's Bench will look after contract and tort issues, which is really important to us within the ACCA syllabus, because the next few chapters are on contract and then tort. Other civil matters which are generic in nature, which don't automatically fit anywhere else, they'll be dealt with within the Queen's Bench. And certain types of writs, such as injunctions, certain types of orders, such as specific performance, may come from the Queen's Bench. We then have the Family Division, which we don't really touch on within this syllabus. So defended divorces, wardship issues, so adoption and that type of situation. Some appeals, if they are family-based, go through to the Family Division. And then the third division is our Chancery Division. This Chancery Division is really important to us as well, because it looks after company law. Trusts are a very, very interesting beast in the world of business, and tax is always important to everybody. We look at insolvency towards the end of our syllabus. When we get to chapter number 11, we'll look at companies in trouble and how to terminate them. So that could be very important to me as well. We also have running alongside these different civil courts. So we have running alongside these different civil courts, different tribunals. There are actually 7 different tribunals. You only need to know about one for this exam. The one you need to know about is the Employment Tribunal. The Employment Tribunal is actually staffed by one legal specialist and then employment specialists. If you don't like what they decide, you can then appeal it. The appeal goes through to the Employment Appeals Tribunal, which will then be staffed by High Court judges and expert laymen. So the High Court judges are more senior legal specialists. If you're still not happy with all of this, and if you're not happy with what's come from the High Courts of Justice, you can then go through to the Court of Appeal. We have got Lords Justice of Appeal within the Appeal Court. So we have Lords Justice of Appeal within the Appeal Court. And they'll hear appeals from the High Courts of Justice, as we've seen, and from the County Court. And from the County Court. At the very top of our tree within the UK, we have got the Supreme Court. And the Supreme Court is staffed by law lords. So these are our Supreme Justices. So these are Justices of the Supreme Court. These law lords are actually independent of the House of Lords, and they will hear appeals from the Court of Appeal, both criminal and civil. So you can have an appeal against a criminal issue, and that will be heard within the Supreme Court as well. And you may find that they've got that exceptional issue of a leapfrog straight from the High Court of Justice. Over and above that, at the moment within the UK system, is the European Courts of Justice. Now, the European Courts of Justice sits above the UK courts because of the way that the UK currently sits within Europe. That will obviously change in the near future. But for the purposes of this syllabus, you need to know that the ECJ, the European Court of Justice, is more senior than the Supreme Court, and they tend to focus very heavily on interpretation of European law rather than UK-based law, although they can look at UK law as well. There's another European court that you need to have an awareness of, which is the European Court of Human Rights, the ECHR. And the European Court of Human Rights is the final court of appeal for anything to do with the Human Rights Act from 1998. There's no appeal from that court. So this is the final court you can appeal to. Now this brings us up to the end of the English legal system. That structure that we've got, the criminal system and the civil system, you need to have a good understanding of the difference between both of those systems. You need to have a good understanding of the seniority of the courts And then when we start looking at the sources of law in part 2 of chapter number 1, we'll start talking about judicial precedent. The seniority of the courts then kicks in again. So do make sure you're happy with that before you move on to part 2, please, guys. Thank you very much for your time and attention. I'll see you all bright-eyed and bushy-tailed on chapter 1, part 2 very soon.